Imagine this. It is a Wednesday morning, 7:45 a.m. You are sitting in the passenger seat of a car at Los Angeles International Airport. Your husband has been in Mexico for 8 months visiting his mother who was sick. 8 months, not 12, not 2 years, 8. He has his green card in his hand. He is smiling when he walks out of customs, and then a CBP officer stops him, pulls him to a side room, and 40 minutes later you get a phone call. He is being held. They are questioning whether he still lives in America, whether he intended to come back, whether he abandoned his permanent residence. He has a green card. He has been here for 6 years. He did nothing wrong. Or so he thought. That story is real. Versions of it are happening every single week across this country. And the most painful part, in almost every case, the person made an innocent mistake. A small mistake. Something that made perfect sense at the time. Something that nobody warned them about until it was too late. My name is Timothy, and I am the founder of US Updates Hub. I have been studying immigration law and USCIS policy for years, and I created this channel for one single reason, so that you never become that story. Today, we are going through 5 specific legally documented mistakes that are silently destroying green cards right now in 2026. These are not rumors. Every single fact I am about to share comes directly from USCIS.gov, Gov the Immigration and Nationality Act, and official U.S. government policy. We are going to go deep, so stay with me through all 5 because the one that applies to you might be number 3 or number 4. You do not want to miss it. Let us begin. Mistake number 1. You stayed outside the United States for too long. And by too long, I do not mean 2 years. I do not even mean 12 months. I mean 6 months, sometimes less. Here is the legal reality that most green card holders do not know. According to the official USCIS policy on international travel for permanent residents, abandonment of your green card can be found on any trip abroad, even a trip shorter than 1 year, if the officer believes you did not intend to keep the United States as your permanent home. Let me repeat that. Even a trip under 12 months can cost you your green card if you cannot prove you intended to come back. So what does USCIS look at? They look at whether you maintained your U.S. family ties, whether your children were in American schools, whether you kept your job here, whether you continued filing U.S. taxes as a resident, whether you kept your U.S. bank account active, whether you maintained your U.S. driver's license, whether you kept your American mailing address. They look at all of these things together. Here is the trap. Most immigrants think the rule is simple. Stay under 1 year, you are fine. Cross 1 year, you are in danger. That is not how the law works. USCIS looks at the full picture of your life, not just the number of days on a calendar. A person who was gone for 9 months but closed their bank account, let their kids stay abroad, and did not file U.S. taxes is in far more danger than someone who was gone for 14 months but kept every single U.S. tie active and had a re-entry permit in hand. Speaking of the re-entry permit, if you know you will be outside the United States for 1 year or more, you are required to apply for a re-entry permit before you leave. This is Form I-131. You apply for it, receive it, and it is valid for 2 years. It does not guarantee your re-entry, but it is strong evidence that you plan to return. And you must apply while you are still physically inside the United States. You cannot file it from abroad, and here is the nuclear option most people do not know exists. If USCIS decides you abandoned your status, they issue what is called a notice to appear. That is Form I-862. It is the document that begins formal deportation proceedings. Not a letter, not a warning, a legal order pulling you into immigration court. And from that moment, your green card is suspended, your future naturalization is in danger, and you need an immigration attorney immediately. Your action for mistake. Number 1. Before any trip longer than 6 months, collect and keep copies of your U.S. bank statements, your lease or mortgage, your children's school records, your employment records, and your U.S. driver's license. Carry them with you when you return. And for any trip expected to go beyond 1 year, file Form I-131 for a re-entry permit before you leave. Do not wait until you are at the airport. Mistake number 2, you filed your taxes as a non-resident alien. This is the one that makes immigration attorneys lose sleep. Because it happens constantly, and it happens not because people are dishonest. It happens because someone gave them bad advice. A tax preparer, a friend, a family member. Someone said you were abroad for most of the year. File as a non-resident, you'll save money. And they did. And they never thought about it again until their naturalization interview or their re-entry at the airport. And then suddenly, a USCIS officer or CBP officer asks, "Have you ever filed U.S. taxes as a non-resident alien?" And that one wrong box checked years ago becomes the basis for a finding of intentional abandonment of permanent resident status. Here is the exact language from USCIS. According to their official page on maintaining permanent residence, you may lose your green card by, and I am reading directly, declaring yourself a non-resident on your U.S. tax returns. That is official. That is documented. That is the law. Here's why this trap is so dangerous. It is on paper. It is signed. It is submitted to the IRS, and the IRS and USCIS share data. So, when you walk into your naturalization interview, they may already know. You do not know they know. And when they ask you about it and you say, "I always filed correctly," and they pull out your 1040 NR from 4 years ago, the conversation becomes very serious very fast. The good news is that if you made this mistake in a past tax year, there is a path to fix it. You file an amended return using IRS Form 1040X, which corrects your original filing and restores your status as a resident taxpayer for that year. But here is the critical point. You must do this before your next USCIS appointment or before your next international trip. Do not walk into an interview with unfixed non-resident tax filings in your history. Consult an immigration attorney and a tax attorney together. Both. Not one. Both. Your action for mistake number 2. Pull your last 5 years of tax returns today. If any of them say 1040 NR or non-resident alien, call an attorney this week. Now, we come to mistake number 3. And this one is the one that shocks people the most because they genuinely believe it cannot apply to them. Mistake number 3. You have an old criminal record and you think it does not matter because it was expunged, or because you were never convicted, or because it happened 15 years ago. Under immigration law, the definition of the word conviction is radically different from what it means in criminal court. In criminal court, an expunged conviction is treated as if it never happened. In immigration court, it still counts. A deferred adjudication, where you entered a guilty plea but the judge deferred the judgment and eventually dismissed the case, can still be treated as a conviction for immigration purposes. A case that was dismissed after you completed a diversion program can still be treated as a conviction. A guilty plea followed by probation can still count even if your record was later sealed. This comes directly from Board of Immigration Appeals case law, which USCIS follows in its adjudications. And under INA Section 237, which lists the grounds for deportability of permanent residents, you can be ordered removed for crimes involving moral turpitude, drug offenses, domestic violence, and aggravated felonies, regardless of how old the case is, regardless of whether your record was cleaned up in criminal court, and regardless of whether you were even aware at the time that it would affect your immigration status. Here is the trap. Most people who went through the criminal justice system were never told by their defense attorney that the outcome could affect their immigration status. Many public defenders did not ask. Many people did not know to bring it up. And so they moved on with their lives. They got their green card, they built a family, and then one day, years later, USCIS runs a full background check for their naturalization application, and something that seemed buried comes back to the surface. Before you plead guilty to any criminal charge, no matter how minor, no matter how routine, you must speak with an immigration attorney first. This is not an exaggeration. A single shoplifting plea, depending on the charge, the jurisdiction, and the circumstances, can create permanent consequences for your immigration status. The phrase to tell your criminal defense attorney is, "I am a green card holder. I need to understand the immigration consequences of any plea deal before I agree to anything. If you already have something in your past, do not assume the worst. There are legal defenses. There is something called cancellation of removal, which allows certain long-term permanent residents to fight deportation in immigration court, even after a criminal finding. But you need an attorney to assess whether you qualify. Your action for mistake number 3. Request a full copy of your criminal history from the FBI using Form FD258, their fingerprint-based identity history summary request. Know your record before USCIS does. We are at the halfway point. Mistakes 1 through 3 are done. Now, mistakes 4 and 5 are where things get truly dangerous because they involve moments that feel completely harmless. Moments that happen in ordinary daily life that can destroy your green card in an instant. Mistake number 4, the DMV voter registration trap. You go to the DMV to renew your driver's license. The kiosque or the electronic kiosk asks you if you want to register to vote. It seems like a normal part of the process. Maybe you checked the box without thinking. Maybe you misread the question. Maybe someone told you it was automatic and you just have to confirm. Maybe you thought you were supposed to answer yes because you are a legal resident of the United States. You were not trying to lie. You were not trying to cheat the system. It was an honest mistake. Under federal law, that honest mistake is one of the most destructive things a green card holder can do to themselves. According to USCIS.gov under INA Section 201A6 CAIA, any person who makes a false claim to United States citizenship for any purpose or benefit under federal or state law is permanently barred from admission to the United States. The law says permanently, and USCIS has confirmed that this includes checking a box claiming citizenship status in order to register to vote. And here's the most important and terrifying legal detail about this rule. According to the official USCIS policy confirmed by the Board of Immigration Appeals in matter of Zhang from 2019, this law does not require intent. You do not have to have meant to make the claim. You do not have to have known it was wrong. You do not have to have understood what you were signing. A USCIS officer can still find you inadmissible or deportable based on this ground, even if you made the claim unknowingly. In 2025, a real case emerged from Florida. A Jamaican citizen and legal resident registered to vote through an online system, checked the citizenship box, and actually voted in a presidential primary. She was arrested under federal law as part of Operation Take Back America. She now faces criminal charges in addition to immigration consequences. That case is documented on the official USCIS newsroom website. There are extremely narrow exceptions to this rule. If both of your parents were U.S. citizens and you lived permanently in the United States before the age of 16, and you reasonably believed you were a citizen at the time, you may qualify for an exception. But for the vast majority of adult green card holders, no such exception applies and no waiver is available for those seeking permanent resident status. The trap here is that many states have automatic voter registration systems tied to the DMV. They are designed to make registration easy for citizens. But for non-citizens, especially those who read quickly, who are nervous, who have limited English, or who are guided by a clear who assumes everyone is a citizen, the DMV counter can become the most dangerous place they have ever stood. Your action for mistake number 4. If you have already registered to vote as a non-citizen, contact an immigration attorney immediately. Do not vote even once. If you are flagged at a future USCIS appointment for voter registration, having never actually voted is a meaningful distinction, though it still requires legal guidance. And every time you go to the DMV going forward, read every single question on that screen carefully before you touch the screen. And if you are ever unsure, leave that question blank and ask a clear for clarification. And now, mistake number 5. This is the one I started this video with. This is the story of the man at the airport. This is Form I-407, and this is the one I want you to memorize before you ever travel internationally again. Form I-407, Record of Abandonment of Lawful Permanent Resident Status. When you read that title out loud, it sounds like something you would never sign voluntarily. But every single year, green card holders sign this form under pressure at international airports, at border crossings, and at ports of entry, believing they have no other option. Here is the scenario. You are returning from a trip abroad. Maybe you were gone for 8 months, maybe 10, maybe 13. A CBP officer pulls you aside. They take your green card. They sit you in a small room. They may speak firmly. They may suggest that you have abandoned your status. They may slide a form across the table. They tell you it would be easier if you just sign. They may imply that if you do not sign, things will become very complicated, and you are tired, and you are scared, and you do not know your rights. So you sign, and the moment you sign Form I-407, your green card is gone. Not delayed, not suspended, gone immediately. You have officially recorded in your own handwriting, with your own signature, that you voluntarily gave up your status as a lawful permanent resident of the United States. Here is what USCIS and immigration law make absolutely clear. Signing Form I-47 is 100% voluntary. A CBP officer cannot legally force you to sign it. They can question you. They can hold you in secondary inspection. They can make things uncomfortable, but they cannot force you to sign away your status. And here's the other critical legal fact. Under established immigration law confirmed by courts across the country, the U.S. government cannot terminate your permanent resident status without giving you the opportunity to fight it in front of an immigration judge. This means that even if CBP believes you abandoned your status, they still need to initiate removal proceedings and give you access to an immigration court where you can present your evidence and make your case. The moment you sign I-407, you give up that right. You skip the court, you surrender voluntarily. And the battle to reclaim your status from that point becomes extraordinarily difficult, expensive, and uncertain. Memorize those two sentences. Write them on a note in your wallet. Save them in your phone. Teach them to your spouse. Those 22 words are your legal shield at the airport. Now, let us spend a few minutes on something equally important, the misinformation. Because there are things circulating on social media, in WhatsApp groups, and coming from notarios, the unlicensed immigration consultants who pose as experts but have no legal training that are getting people into serious trouble. Misinformation number 1, if you have had your green card for more than 5 years, ICE cannot touch you. This is completely false. 5 years is not a magic number that makes you untouchable. You remain fully deportable as a green card holder until the moment you take the oath of citizenship as a naturalized American. There is no 5-year safety threshold, none. Misinformation. Number 2, if your record was expunged, you never have to mention it. We covered this in mistake number 3, but it is worth repeating. In immigration law, expunged does not mean erased. It means sealed from public view in criminal courts. USCIS has access to records that the general public does not. Do not assume your record is invisible. Misinformation number 3. You do not need to carry your green card every day. Wrong. Federal law found in the Immigration and Nationality Act requires every green card holder who is 18 years of age or older to carry their green card at all times. Not in your glove compartment, not in your drawer at home, on your person. The law says at all times. In the current enforcement environment, being stopped and unable to produce your green card can escalate a routine interaction very quickly. Misinformation number 4. A notario can fix this for you. No, a notario in the United States has no legal authority to give immigration advice. In many states, practicing immigration law without a license is a criminal offense. The word notario in Latin American countries often refers to a trained legal professional. In the United States, it does not. If someone charges you money to advise you on immigration law, and they are not a licensed attorney, they are operating outside the law. And if their advice is wrong, you cannot go back to them. You are the one who faces the consequences. Now let us bring everything together with your complete action plan. 6 steps. Write these down. Step 1. Before any trip outside the United States longer than 6 months, build your U.S. ties evidence file. This means copies of your bank statements, your lease or mortgage, your employment records, your children's school records, and your U.S. driver's license. Carry them when you return. Step 2. If you plan to be outside the United States for 1 year or longer, file Form I-131 for a re-entry permit before you leave. You must be physically inside the United States when you file. Step 3. Pull your last 5 years of tax returns today. If any of them say 1040 NR or non-resident alien, contact an immigration attorney and a tax attorney together this week and file amended returns using IRS Form 1040X. Step 4. If you have any criminal history, including dismissed cases, expunged records, and deferred adjudications, request your complete identity history summary from the FBI using their fingerprint-based process. Know what USCIS will see before USCIS sees it. Step 5. Every time you visit the DMV, read every question on every form carefully before responding. Never check a box claiming you are a U.S. citizen. If you are unsure about any question, stop and ask for clarification before proceeding. Step 6. Memorize these exact words and carry them with you every time you travel internationally. If a CBP officer ever presents you with any form and asks you to sign it, you say clearly and calmly, "I do not abandon my lawful permanent resident status. I request to see an immigration judge." Then you stop talking. You have done your job. Your green card is not just a piece of plastic. It represents years of waiting, thousands of dollars, family sacrifices that are impossible to count. The right to work, to live, to build a life in this country. It is not invincible. It can be taken. Not through dramatic arrests, not through some big obvious crime, but through small, silent, ordinary mistakes that happen at a DMV counter, on a tax form, at an airport inspection booth. That is why this channel exists. Knowledge is the only real protection you have, and you deserve to have it. I am Timothy from US Updates Hub, and I am here to keep your American dreams safe. If this video helped you, please share it right now with every family member and friend who holds a green card or is working toward one. One share from you tonight could protect someone's entire future. And join our WhatsApp channel using the link in the description below. We send you instant alerts the moment a new USCIS policy drops, the moment an executive order changes something important, the moment there is something you need to know before the system catches you off guard. Immigration law moves fast. We make sure you move faster. Your status is too important to learn about one day too late. Stay informed, stay protected, and I will see you in the next.